Good day, everyone, and welcome to our annual firm webinar, Strategies from the Frontlines, How to Tackle the Toughest Workplace Challenges of 2025. We're thrilled to have so many HR professionals, leaders, and executives joining us from across sectors. This session is all about the issues that don't show up in the textbook, what's really playing out on the ground, and how employers can respond strategically and confidently. That's what we're going to be focusing on for the next couple of hours. So over the next 2 hours, Joel Smith, Alexandra Pressey, and I will rotate between moderating and being in the hot seat, sharing candid insights and stories from the front lines of our practices. I want you to note that in lieu of slides, we'll be sending all attendees a written summary of key takeaways after the session, so you can stay focused on the discussion, as we've designed today to feel like an inside look at the strategic conversations we have every day with clients navigating complex workplace challenges. You'll notice that the Q&A function at the bottom of your screen is there for the purposes, we'd like it to be used for the purposes of you sharing your questions throughout the session. You can also use chat, because sometimes in these sessions, because we're not in the same room, we're in our virtual rooms, but it's nice if there's something that resonates, or if you have a comment or an amen, hallelujah, you can use the chat. Also, if there's any type of technical issue, if you need to get the attention of our team, you can use the chat for those purposes as well. But please use the Q&A and populate the Q&A with questions as they arise in your minds. If something strikes you as a burning question that you'd like us to tackle, please include it, because what we'll do is we will deal with questions as we see them, to the extent we can weave them into the conversation. And for the rest, we'll tackle them in our closing Ask Us Anything Q&A segment. And so, I really hope that all of you will bring your questions, because it is your chance to bring your toughest or most unique workplace challenges forward for our live insights. Now, a bit more detail or a roadmap of what we plan to cover today. We've designed today's session in acknowledgement of the reality that across industries and sectors, employers are confronting new forms of complexity, from disability management and legal and litigation risks to hybrid work, pay equity, and of course, the escalating challenges around conflict, psychological safety, and leading in a culture of entitlement, which has been really challenging for many leaders. Each of us will take a turn unpacking these issues from a legal, strategic, and leadership lens, helping you connect the dots between compliance, culture, and performance. We'll also be running a couple of live polls throughout the session. Well, I should say not a couple, a few, to get your perspectives and validate whether these issues truly are the flashpoints you're experiencing in your workplaces. So because we have a lot of content we want to cover, I'm going to start us off by asking Joel Smith to join me to dive into some of the most pressing legal and risk management challenges employers are facing right now related to disability management and litigation risks, and how to navigate them effectively. But before we get into Joel's segment, I want to launch 2 quick polls to hear from you about the challenges that are top of mind in your organizations on the themes that Joel's going to unpack. So the first poll is, have you had challenges with employees or their doctors being uncooperative with requests for medical information while managing disabilities? So you've got 3 options there. Yet no, yes, but no more than in the past, and yes, more so recently. What say you? I'm going to got a number of people on the webinar, so I'll give you some time to populate. To my team, can you see the poll? All right.
We can.
Okay. So interesting. I'm going to give just a few more seconds in the interest of time. All right. So you see that, we've got pretty much, well, it's almost split right across the three with yes, but no more in the past, and yes, more so recently, being very close in terms of your responses to the question. So that's informative and validating for us in terms of what we're going to share. There's another poll I want to share with you. Just bring this up. And this one, the question to you is, have you ever challenged a WSIB claim or sought WSIB cost relief? 5 possible responses there. And look, we acknowledge that not everyone is WSIB covered, but for those of you who are, let's hear what you have to say or see what you have to say. All right. So the poll has, hopefully you can see that no, neither seems to be the prevailing answer, with 39% of those in attendance saying that they have not. And there are a few of you, 5%, that have sought WSIB cost relief, and about 20%, yes, that have challenged a claim. So that gives us a good foundation, Joel, to dive right in with the complex areas you're going to cover, starting with this question to you. Employers often think about WSIB and disability management as administrative or reactive processes, something that's handled only after an incident occurs. From your experience, how does that mindset increase risk for employers?
Great question. Thank you, Laura, and good afternoon to everyone. Not good morning. We're on the other end of noon now. The biggest issue there is really it's a missed opportunity. What you need to understand as employers, especially those who have the WSIB coverage, of course, and I see that most of you here do, it's expensive. The WSIB is a very expensive process. HR teams don't always see that line item on the budget. It may be held somewhere else on the employer, but it's really, really expensive. And every claim, every WSIB claim can increase premium rates for all employees. It's not just the premiums for that employee, it's the same premium rate for all employees. And so you have a claim, those rates go up, and the overall cost goes up significantly in many cases. And so it's important to comply, of course, with the requirements, but it's important to minimize the claims, and it's important to ensure that you don't have any lost time or as little lost time as possible due to WSIB injuries to keep those costs down. So like I say, there are, requirements that you have to comply with. There are tight deadlines that you have to comply with, and there's penalties for missing those. So employers really do need processes with clear accountabilities to ensure that you meet the requirements to hit those deadlines and do what you need to do. And overall, really, the only way as an employer to know what happened with an incident is to be able to investigate the accident so you can report the right information at WSIB. And, the other thing that you want to keep in mind, if you don't have those processes, you might lose the opportunity to get WSIB cost relief as well. And so what I'm really talking about there is cost relief through the WSIB's Second Injury Enhancement Fund. It's a short form is SIEF, SIEF. And so the idea there is if an employee had an injury, but they had some prior similar injury that may have resulted in the recovery from their workplace injury taking longer or elongating that period, then the WSIB will actually cover some of the costs themselves for that WSIB injury rather than all of those costs being borne by the employer. But the WSIB doesn't tend to do that on their own. You've got to ask them to do that. And so you need to know about those prior injuries to do that. And then if you do and you make those requests, you can get a huge percentage, sometimes 25, 50, 75, even 100% of the cost to be covered by the WSIB without impacting your premiums for others.
Oftentimes most employers don't avail themselves of, SIEF cost relief, et cetera, because they find the WSIB regime complex. It's an insurance scheme. And even when, the very basic, requirements, a lot of employers miss. And so, I want to just within the WSIB realm, ask you this, because we've supported many clients after workplace injuries where things didn't go as planned, where things have derailed, frankly, that otherwise could have been avoided. What are some real world examples of how a missed reporting deadline or inaccurate injury report has come back to hurt the employer later on?
That's a really great question, and you're right. There are many examples. There's one that I want to really focus on here to help illustrate this. So we have a client who had a situation where they let an employee go for performance issues, nothing to do with any disability or workplace injury, just a performance issue with this employee. And this is a client that, of course, had WSIB coverage. And so in this case, they didn't have a procedure for managers and supervisors to report injuries when they have it. They didn't have a formal process to ensure that these deadlines are met, that the obligations are met. And so in this case, just a few days before the ultimate termination that was already being planned, this employee had reported an injury to a supervisor. In this case, unfortunately, the supervisor either didn't realize or decided not to tell anyone about that. And the employee didn't realize the WSIB reporting obligations at the time either. And so the injury was never reported. And then a few days later, the dismissal happened. The supervisor wasn't involved in that process. And so, this didn't come up in the context of the termination. And so the employee was let go. All seemed to be okay until a few weeks later, this employee got a lawyer, told the lawyer about this injury that they had reported to this supervisor. And then the client got the letter that we expected from the lawyer saying, we want more termination entitlements than you've offered. And that's a pretty typical one that we get, but it also had this surprise about this injury that had been reported and was never brought to the WSIB's attention. And so, through this lawyer's letter, they're not only alleging, termination entitlements are owed, they're alleging reprisal under the WSIB, which is the Workplace Safety and Insurance Act, the governing legislation, as well as discrimination under the Human Rights Code because this employee was let go right after this injury was reported. Now, in this case, there was no discrimination, there was no reprisal. The people making the decision didn't even know this had happened, but the timing didn't look good. And so this is a situation we were able to support the client through that. They were able to avoid some of the huge penalties they could have faced through the WSIB and end up with a decent result. But it very well could have gone another way. And those types of situations, unfortunately, they do happen if you don't have that process in place.
Absolutely. And, another thing, just with respect to kind of fundamental and foundational requirements relate to accident investigations, because they're not just a WSIB requirement, they're a legal and strategic opportunity. So, what should employers be looking to uncover through an effective investigation? And how does that help shape the Form 7 reporting and manage costs down the road?
It's a good question. And for those who don't know, the Form 7 that we're talking about, that's the initial form that employers have to report to the WSIB to spell out really what happened. You have to give the kind of key details, their hours, their compensation, what have you, but also what happened with this injury. And so that's the opportunity as the employer to provide that information to the WSIB. Now, I hesitate to seem like the cynical employment lawyer for employers. I don't want to come across that way.
No,
And I
we're not.
recognize and I recognize most WSIB claims that employees bring forward, they are of course legitimate. Injuries do happen. The WSIB there is there for a really important reason. But the reality is, here's where the cynicism might come in a little bit. Some employees will exaggerate injuries. We do see this. We probably see it more than most because we're the ones that our clients call when it happens. So they might exaggerate what happened, or they might make a claim about an accident that actually happened at home and claim it happened at work, so they can get WSIB benefits where otherwise they might be without any pay for that. And so often those responsible for reporting to WSIB only have the employee's story. So there's someone in an administrative role who has to complete that Form 7. They hear from the employee what happened, or they hear from the manager what the employee says happened, and they don't have the detail from an investigation to determine what in fact happened in this situation. And that investigation might uncover inconsistencies in the story, some other things that are there, and that would create the opportunity to challenge this claim if it's not a legitimate one. And something I want to really note for everyone who might be feeling like, don't I have enough to do? As it's HR right now, there's a lot going on. I don't want to add something else to my plate. These investigations really aren't that complicated. You need to have a process for employees to report what happened as soon as it happened, not only the person who was injured, but anyone who was around and saw an accident as well. You need to speak to that employee, any witnesses, anybody the employee may have spoken to right after the accident to really get a full picture of what happened. and get statements, especially where there's some sort of inconsistency between the report and what others say actually happened. A key one that a lot of employers don't think to do: review any surveillance footage for the area where the accident is alleged to have happened and preserve it. The preservation is key. A lot of surveillance will roll over every week or every month, and then it's deleted if you don't save what happened. And so, get that, preserve it to see what really happened. And then you complete that Form 7 that I was talking about. And it's in that Form 7 that you have a really good opportunity to address any discrepancies that you see in what the employee has reported. You want to do that as an employer right away. It's so much easier and frankly so much cheaper to get the WSIB to come to a decision at the outset about whether this claim actually happened or not, than if the WSIB approves a claim because they just have the employee's story. The employer finds out later that it's not legitimate, and then they have to try to appeal the approved claim. That's much more complicated. That's much harder. It can take literally years to get them to do that. And sometimes you can get it done with just that quick investigation in Form 7 at the outset. And I'm mindful that I'm looking at the number here. 18% here say they don't have WSIB coverage. You may wonder, okay, well, what are we talking about here? Why does this matter for me? Well, these investigations matter no matter what. If you don't have that coverage, you're still going to want to do an investigation. It's going to help you comply with your Occupational Health and Safety Act obligations to investigate certain types of incidents. It's going to help you ensure that just that you know what happened and then put in place any measures where there is a real safety risk, because it's not just about finding out when an employee is lying. That's not all we're talking about here. Of course, it's ensuring a safe workplace. That's what you want to do as an employer. That's going to help you avoid claims in the future, avoid injuries in the future, and of course, importantly, protect your employees. And so these investigations will help you do that and uncover where there's some sort of risk at play. And so I do want to give an example of a situation like this that I just helped a client with recently, just a few weeks ago. An employee in that case reported an injury. This is an employee who previously had reported another injury that did not seem accurate based on some witnesses. I'll say that diplomatically, perhaps. And so in this case, the employee reported another injury, and our client investigated that immediately. Just as I was just saying, all organizations should do. They looked at the surveillance footage, they spoke to witnesses, and yet again, discrepancies like there had been before in this case. And so in that situation, they did that investigation. They shared that information on the Form 7, just like I'm saying you should do. And lo and behold, the WSIB has denied that claim. And that's really, really valuable because it's an illegitimate claim. An employee is trying to get something that they're not entitled to. And that can, again, result in huge cost increases for the employer. And so, taking the steps like our client did there can really help in reducing those costs.
Those are such great insights. And, from our perspective, yes, we may try to not present ourselves as cynical employment lawyers, but sometimes there's cynicism within the organization as well, as it relates to who the accident, who's had the accident. And you also have to be mindful of that, because sometimes that creates this reluctance to fully or thoroughly investigate. It's like, oh, it's just, Joe, he's faking it, right? He's just trying to take advantage. And, you have to override that reluctance because, as you quite rightly say, Joel, the evidence gets spoiled, right? Or it may not exist when you need it to defend the position that the employer is taking. So that great insights there. Let's kind of pull the lens back a bit and talk about disability management generally. So what would you say to employers who want to improve their disability management practices and processes? What practical steps tend to provide the greatest benefit?
So there are a few key ones that you want to bear in mind. I've just spoken about some of those, right? Have a process in place that relates to workplace injuries, but it shouldn't just be about workplace injuries. Have processes to deal with any sort of an injury or accident, right? Be intentional about that. Make sure that everybody understands what they're responsible for, whether that's investigations, whether that's injury reports, whether that's requesting medical information at the right time and asking the right questions and not the wrong questions, importantly, when it comes to disability management. Dealing with the WSIB directly, dealing with the employee, if it's a non-WSIB issue and there's a leave and we're dealing with, STD or LTD, dealing with the insurer or the adjudicator, right? Who's responsible for all of those things and what steps are you supposed to take? Make sure that people know and make sure that you train them on those processes. We tell our clients all the time, you can put in a prime, absolute, ideal process. If people aren't trained on it, they don't understand how it works, it's not going to help in any way, really. And so you want to ensure that your managers, understand the information. You want to ensure that they know what processes to take. When I was talking about the CEIF claims in the WSIB context a minute ago, you want to ensure, for example, that managers know to share information if an employee had a pre-existing injury that may be relevant to a WSIB injury. Sometimes it's just, the manager works every day with that employee. The employee's told them all about this issue they had with their back last year. And then there's a back injury at the workplace, but that may not have come up unless the manager knows that that's relevant and needs to bring that forward, as an example. So, these types of steps, they can really result in massive, massive cost savings. We're not talking
Huge.
about hundreds of dollars. We're talking about tens, hundreds of thousands of dollars in many cases, especially in the WSIB, but, more broadly in disability management, as well as you say, human rights damages are getting massive in some cases, right? Hundreds of thousands of dollars in extra damages, plus termination entitlements and lost wages. So, employers really do need to take those steps, training and putting those processes in place. This is something we help our clients with a lot, and, it really does benefit them.
Absolutely. And it really is a new day with respect to exposures to liability and risk and the costs of being on the wrong side of what an employer's obligations are. So I want to harken back to the poll that we launched on medical information. And the polling data validated that, uncooperative or vague medical information from doctors has been a challenge, and for some has increasingly been challenging. So I want to ask you, how should employers handle those situations while staying compliant with the ESA and human rights obligations?
It's a really good point. I think that was the one we were about a third, a third, a third. So about a third of the audience here today have had increasing issues with doctors or employees not being cooperative in the accommodation process. I'm honestly a little surprised that's not a bigger number. And I hazard a guess that, some of the other two-thirds just haven't seen that many of these recently, and it might just be coming, right? Because this
Or I
really is
might
a
have, or
reality.
I might have cut off the poll too quickly. Who knows?
Because really this is an ongoing issue, and it's not, doctors' fault entirely, right? It's hard to be a doctor in Ontario. This is in the media all the time. It's legitimate. They have too much paperwork that they're not being paid for. And so this is part of what's led to the, recent ESA amendment that, hopefully many on here are aware of, but those who may not know, you should understand that you can't, as an employer, any longer ask for a sick note to support an absence for the ESA sick days. So the ESA sick days, that's three per year for provincially regulated Ontario employers. You can't ask for a sick note anymore to support those. This is similar to, those you may recall during COVID, COVID-related leaves. You couldn't ask for a sick note for similar reasons. The government just sees it as too much work for doctors. Doctors don't want to have to do the work, and the government doesn't want to have to pay for them to do that work. What's that led to? Well, in many cases, doctors becoming less cooperative with employers when they request information for, legitimate accommodation purposes, which employers have an obligation to do, and it's important to do to be able to do the right thing for the employee as well. Doctors sometimes see these requests as really a waste of their time and provide limited information. In some cases, they just see it as just take care of the employee, and they don't understand the broader operational impacts that these things can have and how important it is that the employer knows really what's going on from a limitations perspective to be able to provide the right accommodations. Now it's not only about, doctors not feeling like they have enough time. Some cases they're just reporting what the employee asks them for. Sometimes they have a relationship with the employee, that they find that to be kind of helpful to their patient. I'll give you an example. A few weeks ago, I had a client who received a medical note from a unionized employee. This is an amazing one, truly, and just really a very recent one. The employee sent a doctor's note, and this doctor's note had about 7 very specific, detailed recommended accommodations for this employee. But the employee, in sending the medical note, they accidentally sent an email exchange they had with their union representative just before they saw the doctor, along with the medical note. And that thread showed the union saying, hey, here's 7 specific things that I'd suggest you ask the doctor for in terms of, recommended accommodations. And lo and behold, copy paste. It's the exact same language that we saw in the medical note from the doctor. And so, clearly in that case, the doctor was given that list by their patient, the employee of our client, and they put it on their medical note saying, this is what we recommend. And so I know from talking to so many of our clients, employers are frustrated by this possibility, and it feels like doctors are doing this. Well, here's, some validation when you're feeling like, is this really happening? Am I just believing something that's not true? No, it does happen. The doctors are saying what the employee wants rather than focusing on what the true medical recommendations are. The best way as an employer to manage that is just be intentional in making these requests, right? We often help our clients with detailed letters asking doctors for information about the employee's limitations, making sure they ask the right questions. Again, not asking the wrong questions. I mentioned that earlier. So, for example, not asking for diagnosis information. As an employer, you're not entitled to know what the employee's diagnosis or disability is. You're entitled to know what the limitations are that relate to the work that arise from that diagnosis. So get that right information, ask specific questions. That helps the doctors know that you're not asking for too much, and so they may be more willing to help and give the information. But it's also that they're going to then have a harder time not giving you the right information, just saying what they want to say. They've got to answer those questions they're being asked to, and so oftentimes you're going to get better information by asking specific questions. And so, does that fully resolve any issue with doctors not being cooperative? Unfortunately, no, but staying on it, making sure you're asking the right questions is the best way to get the right information. Now, again, I mentioned the ESA prohibition on sick notes. Employers should just bear in mind when you are doing this, make sure that you're not asking for a sick note in a way that would violate the ESA. And in many cases, it's pretty easy to do that because only the first 3 sick days per year are going to be protected by the ESA in that way. And so, often you can wait until the fourth sick day of the year before you ask for the medical note. There's other ways to deal with this as well that, I won't get into in detail now, but that's a pretty simple general rule to follow to try to ensure that you're staying on side. Of course, for unionized employers, you also want to look at what does your collective agreement say? Are there any restrictions on medical notes there? Because sometimes there are.
Well, we know this alone could be a webinar on this topic. And just to underscore that, we have in the chat, and I notice it's only sent to host and panelists. So I just want to share how this is resonating in terms of issues that others are seeing. So there's a comment, I've had employers ask for various accommodations, and when they do not want to go to a doctor to give me the information, I need to work with them on an accommodation plan. They have dropped their request. So they dropped the request once. There's a response like that. Somebody shared as well that something we're dealing with is having zero information because of the third party between us and the employee, someone off on STD or LTD, and us knowing nothing about the situation at all. And then finally, just to share, again, showing that this is resonating, generic mental health issues are problematic when I get a note from a family physician saying the employee cannot be subjected to stress or strict deadlines. That's something we see, consistently. Anything to kind of to echo back from these comments, Joel?
I'm not surprised by any of those, as you say, Laura. We hear these from clients all the time. There's ways to deal with them. I'm not going to get into too many specifics about them. The one thing I would like to note, the issue around STD and LTD, not sharing all the information and then the employer kind of being stuck. That's a key one. And the best way to avoid that is, something else that you should be doing as best practice generally anyway, which is asking for your own medical information. Don't rely on that third party. When you do that, what can happen is that you may be found to be not complying with your procedural duty to accommodate. Because for those who don't know, accommodation, that obligation really has two key parts as an employer. The procedural duty, which is get the right information, ask the right questions, ensure that you gather the right information to be able to accommodate, and then the substantive duty of actually providing reasonable accommodations the employee needs. And so if you're just relying on LTD, who are, they have privacy obligations not to give you too much information, you're a little bit in no man's land. You don't really know what to do there. And so if you're asking the employee directly, that's going to be the best way to ensure that you're getting the right information, you're complying with your obligation. And in many cases, you may be able to help accommodate and get them back to work because the insurer doesn't actually know what the work fully entails. They have an idea, but they don't get all that information. You do know. So if you ask those questions, you may realize, oh, you know what, we can accommodate that. Let's get this person back to work and get them being productive again.
Not surprising. On this theme, there are a number of questions that are flowing in. I'm so glad that we have designated a significant Q&A at the back end, because that's when we're really going to get into these questions. But there's one I do want to ask you, because we may forget the share of the story that this relates to. So the question is, what did you do with that case? How did you argue it with the union, the one you just told?
Interesting question. I'll be mindful of my client's confidentiality here, so I won't get into too much specific. But in that case, where you are getting that in, and I'll kind of generalize this, just to ensure that that's the case. So when you are getting that information that isn't accurate, I mean, frankly, you can call them on it, right? That's the starting point. Ensure that you flag that this is something that you're aware of, and that's not something that you can accept. You need to know the doctor's own opinion, right? And so you can go back to the doctor and say in a note that you have the employee go to the doctor and provide to them, here's our understanding of what happened here. What we're looking for is your medical opinion specifically, right? So you ask them for the doctor's medical opinion about the limitations, and then you take that into account. And the other thing that you can really, that's really valuable as an employer in a situation like this, and broader context as well, is make it clear to the doctor that you're not just looking for their recommended accommodation, because they only have half the story. They have the employee's medical issues. They don't have enough information about how your organization works, what this person's job is, and how you might be able to modify that to accommodate. And so really the employer with working with the employee, and in this case the union, is best positioned to figure out what's a reasonable accommodation in the circumstances, having in mind the limitations information from the doctor. So be clear to the doctor, I'm not just looking for your recommendations. I want to know what the limitations are so I can take that back and figure out how I can accommodate here. Right. And that's how you can really kind of get around these situations where doctors are just trying to kind of, foist whatever the employee is asking on you.
All right. Thanks for that. In the interest of time, I'm going to do a gear shift to talk about litigation risks and lessons from the courts. But to validate the experience of those of you on the webinar, here's a question for you. Have you seen a recent increase in demands, claims from lawyers acting for former employees? So we're focusing on the increase. It's hard to know when to click end poll because it keeps moving. So I'm trying to make sure we get to when I stop seeing the movement, I'm going to end the poll. All right, I'm going to end it here. So the yeses are at 42%, no's at 58%. And it's interesting, of course, where this is our kind of our sample here, but one thing that we certainly can say, Joel, in our experience, that we are seeing more and more employees bringing claims against their employers than we have in years past. So there is some validation here at 42%, but across industries and sectors, it just has been the case. It's a new day. It also kind of feels like certain employee side lawyers are driving that increase. We're seeing their ads on the subway, hearing them on radio shows, even reading their newspaper columns. What would you say is behind this rise in litigation, and what do employers need to know to help them prepare for and defend these claims?
Thanks, Laura. It's a great question, and I'll try to be as concise as I can because there's a lot that I could say on this one. As you said before, this could be a whole segment of itself. Of course, law is a business, right? That's one point to bear in mind. Lawyers for employees realize that employers don't want to go through litigation. It's expensive, it's time consuming, and oftentimes, many employers will settle even claims that don't really have a real basis. And so they're bringing more of those claims than they may have previously. As you said, marketing is part of it as well. Lawyers are getting better at promoting themselves, and so employees are more likely to actually reach out to these different lawyers to ask for help, and then you're getting more claims there. And then a big one is just really our courts, right? The reality is, as an employer in Ontario, I think all of you here likely know this. Our courts are employee friendly. It's not a secret. We really can't beat around the bush there. They are. The system is weighted against employers in many ways. And so that's the reality. And so our courts, in accordance with that, continue to recognize claims that they wouldn't have really in years past in a variety of different sectors. And that encourages these lawyers to keep on trying new claims. The courts are recognizing new ones. Let's keep trying. And so, one example we see that with, of course, is termination clauses. It's been, 15 years now that lawyers on our side, acting for employers have really essentially been in the battle with the courts, right? The courts continue to move the goalposts on us. The termination clause is seen as valid. Courts have said that certain language is valid, and then another judge says, actually, you know what? I think that's a violation, and that's not going to be something I'll enforce anymore. And so, that's just one of the many areas where we're seeing this shift from the courts. And so, as an employer, there's a number of things that you can do. Obviously, ensure compliance is going to be a key one, but broadly, there are some options, right? One is going to be mindful, be aware of the litigation process. For example, be aware of mandatory mediation. There's a number of regions in Ontario, including in Toronto, where mediation is a mandatory step in the litigation process. And usually, not always, but usually, it's the first step after statement of claim, statement of defense. And so these claims often will settle early at mediation. And so, employers may have this idea of litigation as, discoveries, those who haven't been through the process, you may know it as a deposition that you've seen on TV, being asked questions under oath, trials, all these different witnesses, a lot of work. But the reality is a lot of them are going to settle very, very early at mediation, and it's not such a big, time-consuming, expensive process. And so, employers that are willing to stand firm in response to these unreasonable claims and really force litigation if the employee is not going to be reasonable, they can realize really huge savings. And so, in many cases, employees won't even litigate, weak claims. They'll send you a demand letter. We see this all the time. They're threatening, litigation. They're saying if you don't give them a settlement in a week, they're going to bring a claim against you for hundreds of thousands of dollars, right? They make all these different allegations. And, I can't tell you how many times in just the last few months I've helped clients with those claims where there isn't really a basis for them respond and say, essentially, call your bluff. I don't believe you. We're not going to make an offer. We're not going to negotiate with you. This is baseless. If you need to sue, then sue and we'll go have the courts deal with it. And so many of those cases, they just go away, right? They end up disappearing. The lawyers realize that it's a weak claim. They're trying to threaten litigation to get you to give them something. You don't, and you move on. Sometimes it goes to litigation. And again, you can get that mandatory mediation early and get a resolution. But, in many cases, you don't even get to that point.
Yeah, and just given the era that we're in, how courts have been deciding these cases, yeah, I mean, there are a lot of lawyers that will tire kick, pressure test, and see if something falls off the tree. But you're right. In our experience, we've held fast, and a lot of them have backed down, and the claims go away. But there's also another concerning trend I want you to touch on, and that's we've noticed courts are increasingly awarding bad faith damages for conduct that wouldn't have raised red flags a few years ago. What kinds of employer missteps are attracting these awards today?
It's a great question, and it's even calling it missteps is challenging to me because
Yeah.
the courts they used to recognize that not everyone's perfect and does everything exactly right, and it used to be that's okay. Employers intending to do the right thing who resolve things where they may have made a innocent mistake, they're not going to hold that against employers and award extra damages, but that doesn't always happen anymore. And so when we're talking about bad faith damages, the broad idea that we're getting at here is employees are entitled to certain termination entitlements. I'm sure most of our audience here today knows, there's statutory termination entitlements under the Employment Standards Act. There's contractual termination entitlements, which may be the same as Employment Standards Act, could be more. And then if you don't have that enforceable termination clause I was talking about, then there's common law damages, which can be, up to 2 years of compensation. So that's kind of I'll call it the baseline termination obligations. But then employers can also face bad faith damages awards where the courts say they haven't acted fairly to the employee, and so they award tens of thousands of dollars extra against the employer to pay to the employee at the end of the day. And so it used to be really serious misconduct that we're talking about. Employers, going out of their way to disparage employees, making things up to make it harder for them to get a new job after the termination. Employers just blatantly lying about, certain different things in the termination meeting or harassing the employee in the context of termination. But now we're seeing things like, inadvertently paying statutory termination entitlements a little bit late, or inadvertently, issuing the record of employment a little bit late because of just an internal, logistics issue. Different things like that, also termination letters that we sometimes will see that inadvertently are written in a way that the employee perceives to mean they have to sign a release just to get their minimum entitlements, as opposed to, what's intended. They have to sign a release to get the extra amount that's offered, but of course the minimums are going to be paid either way. These are things that we've been seeing courts awarding damages for, and lawyers are jumping all over those things. So that's something we're really helping clients a lot with. Making sure those processes are in place, that they're preparing before they get into termination meetings and those processes, so that they ensure they know what those deadlines are. Everyone who's involved knows what they need to do and when they need to do it, so you can avoid these kind of simple mistakes that are now resulting in more damages than they used to.
We could camp here for I'm in it, so to speak. In the interest of time, I have one more question for you, and I want to harken back to something that you mentioned moments ago, that we're seeing more employee side lawyers encouraging employees to bring claims based on circumstances that would not previously have led to litigation. One area where that's showing up is with more constructive dismissal claims. Well, not a day goes by do we not see allegations that someone's been constructively dismissed? What kinds of workplace changes most often lead to constructive dismissal claims? And how can employers mitigate those risks?
Yeah, it's a great point. We really are seeing those more and more these days. Now, for those who don't know, constructive dismissal, that's a concept in the law where if an employer makes a substantial unilateral change, so the employee doesn't agree to a significant term of employment, then the employee can treat that change as though the employers let them go without cause and demand their termination entitlements in response. And so, just like I was saying before, historically, this worked a little bit differently. Historically, these claims related to really major changes, a huge reduction in pay unilaterally, or a major demotion from, back down a level or two in the hierarchy of the organization. But more recently, we're seeing them for more minor changes. Like if the employer just, moves their office. I helped a client a few months ago with a situation where they moved their office 2 kilometers just down the street because the lease was up and they got a new space, and help them with multiple constructive dismissal claims from employees saying, that change, having to go 2 kilometers, down the street to go to work, that was constructive dismissal. And so, those were not legitimate claims, in our view, and we help them deal with that. But some changes in work location, they truly can amount to constructive dismissal risk. This is relevant right now with the big push that we're seeing to return to office. That's a big one where, there can be some really serious risks for employers that may not realize that. I'm not going to get into that in detail. I know Alex is going to cover that in her segment up next. So I'm going to wrap up there and ask Alex to come up so we can talk about return to work in some more detail.
All right. Thanks, Joel. Everyone, keep your questions coming. We're monitoring them and we will tackle them at the end.
Thanks, Laura. All right, Alex, it's my turn to get off the hot seat. Your turn to get on it.
I'm looking forward to it, Joel. What you got?
Let's dive in first with a couple of poll questions to really kind of set the stage for your segment. So first off, I'm going to open one up here, and Alex, if you could let me know if I'm doing anything wrong from a tech perspective here.
No, it's all good.
All right. So the first one, this relates to change management. So the question is, have you had challenges managing change in the workplace, like new policies, new practices, new employment agreements, et cetera, recently?
I'm just fascinated. I'm watching. There's a lot of rapid fire answers to this question. So sounds like it's resonating with our audience.
Right. So like Laura was saying, I'm going to let the numbers kind of slow down in the movement before we end this one. I think we're slowing down a fair bit now. Why don't we end it there? So on this one, we've got three options. No at 22%. Haven't had challenges managing change, and kudos to those of you who haven't had that challenge. I know most are, and I think the numbers do bear that out. Yes, but no more so in the past, 35%, and leading the way significantly is yes, more so recently. Employers are having more challenges with this at 43%. As I said, that's validating for us. That's certainly what we see in our practice. Let's do one more before we dive into some questions for you, Alex. All right, hopefully that's out for everyone. So this one, the question is, have you been hearing complaints or murmurings about fairness and flexibility? So the idea here, are you hearing, among your workforce, people making complaints or some chatter about things being unfair, not being flexible enough, that sort of thing? All right, I'm just going to give it another moment for those of you who haven't had a chance to click one yet. The options there being, yes, you have heard complaints or murmurings about fairness specifically, yes, about flexibility specifically, yes to both, and then no. So I'm going to wrap the poll there and share the results with you all. Not surprised here either. Only 22% have not been hearing these kind of murmurings or complaints at all. And more than half, 54%, are hearing complaints, murmurings about both fairness and flexibility recently. So with that, why don't we dive right in, Alex? Like I say, that's validating and not surprising at all. Like we were just talking about in my segment with Laura, one of the key sources of constructive dismissal claims that we've been seeing recently relates to employers requiring employees, some of those employees who haven't really been to the office much recently, or maybe ever in some cases, requiring them to return to a centralized office. So even with the constructive dismissal risks, we're seeing a huge trend here. Obviously, I'm sure everyone here saw the Ontario government directing public servants back to work recently. The major banks have all this fall been bringing a lot of their employees back to work for 3, 4, 5 days per week. Other employers are following suit as well. So, Alex, what's driving this renewed push for in-person work, and what kind of challenges are employers running into as they try to bring people back?
That's a great question, Joel. And I think, definitely one that I'm hoping will resonate to all our attendees. And I will say another good afternoon and thank you for joining us through these topics. There is a lot to talk about. You started me off with a real easy question here, Joel. The reality is that to a certain extent, the pendulum is swinging back from where we were a few years ago when a lot of these practices started and were really, launched by employers for many reasons. And one, I don't like to say the P word anymore, but the pandemic. That was it. That's where a lot of this happened, but not for everybody. Right? So, what we're seeing in the current environment that we have is that employers are increasingly focusing on culture, collaboration, and accountability after years of remote work. And a lot of that, what we see from talking to clients is that, frankly, a lot of workplace issues are easier to manage in person. A lot of managers, maybe who may be new managers or may not have very significant leadership experience, do struggle to manage remote teams. It's easier to identify some issues when somebody is in the workplace. And in some workplaces, to a certain extent, there is a little bit of a rose-colored glasses effect that we've seen of, the good old days when employees were productive, they were there, they weren't, doing their laundry in between meetings or whatever the case may be. And sometimes we forget about, the time spent with, proverbial water cooler talk. The expression is there for a reason, right? And so sometimes, we look at that and we're thinking, okay, well, there are certain issues here. How do we change them? One of the big ways is changing the ways in which we work. And one of the biggest changes for a lot of organizations is where people are working. And public and private sector leaders are responding to different tensions, from a productivity and cohesion issue. There is this perception that engagement has dipped. Employees have different needs, they have different wants. This is a somewhat generational issue in the workplace. And of course, we're running into a lot of these as we see different generations filter in and out of the workplace with different priorities and different ideas of what they want out of a career or a job or anything like that. And also we're seeing that, employers are less tolerant of certain types of behavior and certain issues and certain demands from employees. And this is, partially due to the fact that it's a really different environment that we're in than a few years ago when there was really a scarcity of talent. And we saw employers bending over backwards, making ad hoc kinds of arrangements and really, sometimes over-promising to bring in talent, whereas now we're in a situation where employers don't necessarily feel the need to do that anymore. And we're also looking at the fact that, there's a lot of pressure that impacts businesses with things that are happening in the media. So the government is saying, in Ontario, people, we need you to come back to work 5 days a week. You identified some of the big employers that are doing the same thing. And so, that starts a bit of a trend that employers either feel pressured by or feel like they can cling on to and say, well, look, everybody else is doing it. We want to do the same thing. And sometimes they haven't had a chance to entirely think out how and why that's necessarily the best idea for them. But the reality is that a lot of the employers that we're seeing in the news often have a lot of pressures and concerns that don't necessarily have anything to do with their specific employees, the potential legal risks they may face in those relationships. Some of the big employers are looking at it as a potential numbers game because they also have other realities that are really weighing on them, whether it's, political, whether it's obligations to clients, to stakeholders, to constituents, whatever the case may be. And something like the constructive dismissal risks you flagged aren't really making it to the top of the list. And legally, the constructive dismissal piece is the biggest one. You've saved me some time. Thank you for walking through constructive dismissal. But the way that it shows up in a hybrid or remote work environment is really that if employees' place of work has become an implied term, and the argument is that this is a fundamental term that underlies the employment relationship, changes to that can lead to employees saying that, well, you've clearly demonstrated that you don't intend to be bound by our employment relationship the way that it is because I've never actually been in the office. Or, I moved 3 years ago to, 3.5 hours away, and there's no way that I can make my commute, and you knew. And so really the issue that employers are facing here is that they need to look at what is happening, why they need to make the change, and consider how best to approach it to try to address some of these risks, and consider sometimes, maybe you're prepared to take on the risk and you're prepared to have to address a few issues for that more global shift in how you do work. But really understanding that potential risk and evaluating it clearly is one of the first steps that you have to take.
Yeah, it's a great point. We have a comment here. Again, it's just coming to the hosts and panelists, so I'll share with everyone else. That really illustrates the point that you're making, Alex. Every employer is going to have different priorities, different reasons why they might need to look at in-person work. We have a comment that, that this person has pressure as a municipal government to have staff on site. When taxpayers come in, they expect to be able to talk to someone in person. And it's a great point, and one that, a private sector entity is not going to be dealing with at all, but they might have other reasons why they need someone in person. So, Alex, all really good points. Now, to shift gears only slightly, I'd like to ask, many employers are relying on these temporary pandemic era remote arrangements that were never actually formalized. You're talking about situations at the end of your last answer there that, there are employers that just don't have anything in place and they've just kind of left it be, but some have something that they may feel they can rely on, right? There was something that was temporary a few years ago during the pandemic around, hybrid work or remote work. What do those employers risk by leaving those policies vague or unenforced?
It can create a lot of challenges, and Joel, as we've dealt with quite a few of those over the years. I mean, ideally, what would have happened, and I'll just take a step back before I answer your question. Ideally, what would have happened is at the point where the temporary became the thing that as an employer you decided was really going to work for you, you would have codified it. So you would have considered, okay, what's good about this? What are the pros? What are the cons? If this is where we're going to settle, here's why. Let's tell everyone, and then let's make sure that we're doing something to paper it. If we had a memo that we sent out saying we're going to be doing this for 6 months, well, maybe that's now a policy that says here's what we're doing going forward. If we haven't updated our employment agreements for some time, maybe we do that now, and again, make it clear that this is the arrangement and the expectation. But we've been dealing with years and years of uncertainty. All sorts of things have happened to Canadian employers over the last 5 years, and things keep happening. And, sometimes the ideal would be to have time to sit down with these things, but sometimes as a people leader, you're also looking forward and saying, okay, well, are we sure? Should we wait a little bit? Because here's what I see on the horizon, and maybe I need a little bit more time. The reality is that sometimes even, temporary stability is better than the temporary de facto terms of employment that have accidentally been created by not saying this is what our reality is and let's just codify this for now. When implied terms are created, that makes it difficult for employers to shift because you might not even know necessarily everything that's been going on in your workplace. And this is something that we see very, very often. I was speaking with an employer not too long ago, and they were trying to increase number of days in the office. They were having issues with one specific employee who was quite resistant. And when they, got to talking to people individually, they asked why, and they said, well, I had this discussion with my manager. This is what we agreed on. Like, here are the terms. Basically, everything was in an email and writing, and everybody had agreed. That manager had since left the workplace, had never told HR or their own leader, and so nobody actually knew about this. And so we're increasingly running into these issues because of the uncertain environment that we were in. some managers may have approved things on an ad hoc basis, and before you can even really do anything, you have to figure out what all of those arrangements are. And it does tend to get quite challenging. What happens is that employers really lose that flexibility to make future changes without significant effort because proactive policy cleanup and, when nobody is too focused on some of these issues makes it easier. But when this is something that's become top of mind for employees, everybody's, got an opinion on return to the office now, people are digging their heels in, it's much more likely to be met with resistance. And that makes it quite challenging to manage.
Yeah, great points. And the situation that you raise reminds me of so many different things that I've dealt with my clients as well. Now, we've been talking about hybrid remote work as, maybe something temporary, employers wanting to bring people back and the issues they face there. Another issue that we face related to hybrid and remote work relates back to accommodation, like I was talking about earlier. So, when we're talking about hybrid remote work, what we're increasingly seeing is requests for accommodations of remote work. So somebody who does work in person all the time or some of the time, asking for an accommodation of working remotely for a period of time because of whatever, medical limitation they might have or other, human rights reason that they have. So, Alex, do you think that hybrid or remote work itself has become an accommodation expectation of employees? And then if so, how can employers manage that risk without setting really unsustainable precedents?
I think it absolutely has. And certainly if anybody has a comment that they want to share with us in the chat, let me know because I'd be curious if anybody feels otherwise. But increasingly, remote work is now seen by a lot of employees as a right, not a privilege. And that's just not legally accurate in most cases. But it even starts with having to pull the lens back a little bit further when we talk about some of those accommodation issues. Because one of the realities we're seeing is that employees are getting a lot more familiar with the terms of art related to some of these issues. And a lot of people are saying, I need accommodation. They understand the principle of accommodation and that it can benefit them, but they're using it to describe what otherwise might be a lifestyle preference, whether it's related to a potential, medical need or a family status need. And the difference lies in, is this something documented that requires a medical need or a legal protection, or is it not? And so a lot of what employers need to be doing is just making sure that everybody who's going to be getting these requests is really familiar with their processes and policies around accommodation. Ask questions, make sure that you're requesting supporting documentation if some type of human rights need is cited. Make sure that it's always a good faith process. Just because not every request triggers our duty to accommodate, as we're saying, you don't want to fall into the presumption that people are not being honest. Start with the presumption that it could, but ultimately, if you determine that they don't need an accommodation and they certainly don't need remote work, that might be a reasonable place to land. Because again, I know we've said this, we keep coming back to it. Accommodation doesn't have to be perfect in the circumstances. It has to be reasonable and sustainable. The other thing that I always want to note, though, is because I think sometimes, we think of employees potentially taking advantage of the existence of hybrid or remote work. But sometimes the existence of remote or hybrid work is of benefit to the employer because, what we have also seen is employees who are perhaps met with a situation they're not particularly fond of in the workplace saying, can't work. And sometimes what we've been able to assist employers with is saying, well, the medical limitation is you can't be in the office. Go do your work from home. We still expect you to meet these deliverables. We still need you to do these things. You're just not going to do this in this space. And you know what? That's fine with us for whatever reasons.
Yeah, it's a great point, and it reminds me. I was just chatting with Faraz on our team just the other day. He's been supporting a client through a situation where there's an investigation, a complaint by one employee against the other, and the employer's been able to manage it by having one person work from home, and it relates to a limitation they have anyway, and otherwise they may not have been able to be in the workplace together. So a really good point. Um, let's zoom out quite a bit on hybrid work. I'd like to ask you a big philosophical question, perhaps. If you look ahead a year or two, do you think that hybrid work's going to stabilize, or are we still in the middle of this process of, figuring out what normal is?
Well, I think in all areas of life, change is constant and important. So you started off philosophical. I'm going to continue that way. But to be a little bit more practical for our attendees, I do think we're still in the correction phase. 5 years feels like a lot. 5 years over the course of the life of many businesses and many people's careers is not that much. The reality is that, as I've mentioned, some of those early pandemic promises to employees weren't sustainable. Some of those realities have changed. But I think we can see increasingly a gradual stabilization as employers align their policies, their productivity needs, their culture. And I think what's really key to note is that the employers who are going to find that stability soonest are those who have an opportunity to be intentional and really, sit down, think this through, figure out what it is that they're going to want and how to best communicate that, and not defaulting to old models or necessarily reacting to trends. You can take advantage of trends that are there, but you don't want to be in reactive mode all the time.
So we have one question that I don't want to miss the opportunity before we shift gears a little bit to ask you here, Alex. And so, we were talking about accommodation and remote work as an accommodation. We talked about it from the medical limitation perspective, but then also, family status accommodation. And so we have a question, where this attendee was more aware of the kind of medical limitation accommodation than this idea of family status accommodation. So, what are some examples where for family status accommodation, someone might need the right to work remotely?
Certainly. So one of the things that we saw is, I'll use the Greater Toronto area as an example because it's easy, frankly. Not very easy to get childcare for young children. And often the places where parents are able to have their children cared for have shorter hours. And it might be, 9 to 4 or, 8 to 5, kind of if you're lucky. And so a lot of the requests tend to be, well, I need to work from home on these days because I need to pick up my child. It might not necessarily be I need to work fewer hours. It might just be, I can make it to the childcare to drop off my child and get back before work hours or to pick them up, but I can't do that from my office that's 40 minutes away from my home. And so those tend to be the most common ones, but similarly things related to elder care. So increasingly, given the economic situation that we're in, and the fact that we do have a largely aging population, people are taking care of their parents as well. So they might be dropping in on somebody, and things like that. So often the family status related request is, look, a couple of days a week at least, I have to be close to home. And sometimes it's more than that. We've seen requests as well where it's, I have a parent who's really not well. I need to be within 10 minutes of them in case something happens. I'll be at my desk, I'll be responsive, but I need to be there for an emergency. You don't necessarily have to allow this as an employer, but you do have to engage with it because it may very well be an accommodation need, might not be a preference. But there are some steps to take to make sure that you're satisfying that procedural duty to accommodate that you mentioned earlier on, Joel.
Great points. Alex, I want to shift gears again now, as I said that I would, and call back a little bit to the poll that we had. We asked everyone if they've been seeing, the murmurings of fairness and flexibility. And I think we're at about 80% have seen murmurings of one or the other or both. So, I think this will resonate with everyone when we say this is something that you're dealing with. You're seeing concerns about fairness and flexibility at work. And we're talking about that in the context of hybrid work, remote work, but it also comes up in other contexts. So another major fairness issue that we've been seeing is how people are paid. It feels like compensation transparency and pay equity has become another big front in the workplace fairness discussion. Why would you think that is?
Well, I would say part of it is 54% of attendees said people are getting live to and really talking about and prioritizing issues of both fairness and flexibility. I mean, if we count everyone, almost 80% of our attendees said that they've heard people say, either things aren't really fair, they're not flexible, things have changed. I think we had a great point from somebody saying, over time, growing from a small family business to a medium-sized business, and employees are now saying, well, things are becoming too corporate with policies, and then it's not as flexible or fair. Which isn't necessarily fair of them to say, right? But the perception is important. And what we're seeing, again, with some of the social and generational shifts I mentioned earlier, is that employees want transparency, both in where they work, and how they get paid. And increasingly, there's normalizing open pay discussion. Plus, we've had some things happening legally. Over the last, well, it feels like forever now, but for months and months and months, there's been discussion of pay transparency in Ontario, it feels like all of those things have been around forever, but really the pay transparency requirements themselves about publishing job ranges and things like job salary ranges and things like that aren't coming into force until January. But a lot of employers have started thinking about this. The issue has been, though, that often there's an intermingling of issues. So employees are intermingling pay transparency that they've heard about with issues like pay equity or equal pay for equal work. And so pay equity, we're looking at systemic gender-based comparisons, female job classes versus male job classes. And these are requirements that have been around for decades, since the late 80s. But they're often confused with pay transparency, which is the new hot thing, looking at this disclosure of pay information. And they're also confused with equal pay for equal work, which is something that, came in with the slew of changes that the former provincial Liberal government put into place. But it looks at fairness between same or similar work, so same pay regardless of sex, employment status, or employment type, and that's more person to person. And so there's been a lot of this confusion, which leads to incomplete compliance for employers, and sometimes complaints in the wrong space. And so one of the things that we've been seeing increasingly is people making a complaint to the Pay Equity Office in Ontario, when really what they're making a complaint about isn't, I think female job classes at this employer are paid less than male job classes of equal value. I personally, what are saying is, I personally feel I'm not being paid enough for my job. But once you start that ball, there are certain things that happen that neither the employee nor the employer can really stop, and then the Pay Equity Office goes and does its audits, and there are quite a few issues that occur, and so all of these things are contributing to this rise of conversation.
Yeah, really good points. I'm glad that you discussed the kind of differences between those concepts because it really is something that employers are often, misunderstanding, and certainly employees are as well, like you say. So, we're seeing more organizations, more of our clients get ahead of the legislation, the upcoming obligations around pay transparency by voluntarily posting paid ranges on job postings, initiating pay equity reviews themselves before that complaint that you're referring to, gets made, and then the pay equity office is involved, talking more openly about pay. What are the upsides? What are the downsides of being proactive in those ways?
There's definitely things in both columns, but I would say that the upsides greatly outweigh the downsides. The nice thing about trying to initiate these things is if you do it yourself and you pick your time, you as the employer get to maintain some control over the process. And that's a really big one because some of these processes can be very, very challenging. When you are asked to demonstrate that you have maintained pay equity, going back to whenever you had your 10th employee, so for some organizations, again, back decades and decades, for some, maybe not so long, that's a very hard exercise. And the thing to keep in mind is that liability doesn't actually stop. You could, in theory, owe people decades of retroactive pay. When you're proactive about it, you can address some of those issues, you build trust, you can either retain or attract employees by showing that you're the kind of employer who cares about that in a space where, again, the workers who are coming in more and more so are interested in this, and it can help support your employer brand. But again, it also means that you do things on your own timeline. So, gave the example of what happens when somebody makes a complaint and then, the pay equity office sends somebody and they're managing you through the process. They have strict deadlines. If you don't have the resources to deal with that, they don't particularly care, honestly. There are mechanisms that, we've used as counsel to say, okay, look, like, let's be reasonable, let's have more time. But when you do it yourself, we've had clients who've said, okay, we want to do this work. An emergency has arisen and they say, okay, well, we're going to push it back for 5, 6 months. And, sometimes that means that you have to adjust your communication strategy internally, but largely it's fine because you're still doing the work, and it's on your own impetus. Of course, the downsides are when you start digging into this, it may expose internal inconsistencies. Sometimes it can create more morale issues if you have to tell people, look, there were these discrepancies, but you get to really control that narrative, and that helps. So the best approach really here is always to start that internally. Look at things before you do anything to go public. Look at your internal pay, review your systems and make sure that you're, talking to your managers as well to address some of these issues so they can flag for you if something is happening and you can address it early on.
Yeah, great points. It was just yesterday I was talking to a client who was intending to do their own pay equity review for that exact reason that you're saying. They want to be in control of the timelines. They want to be able to control how it works. So great points there. Let's really kind of zoom out, sum up. I've got a question for you here. Big picture, if you were to leave employers with a few key takeaways on navigating pay equity, navigating pay transparency, what would you highlight?
I would say a big thing is to be informed. So, like I said, pay equities at some point fell off a lot of organizations' radars. And the reality is that the requirements apply to pretty much every employer in Ontario, and many, many, many of them, unfortunately, are going to be at least slightly offside if they haven't been demonstrating that they've been maintaining pay equity, even if they did achieve it at some point. And so sometimes this means you're going to have to go and revisit your old data. What have you done? Do you have anything? In some of those transitions that we were talking about in remote work, sometimes information gets lost when a manager moves and things like that. That's happened in pay equity too. The people who were in charge of this or who may have really been working on this because it was their passion project at a time 20 years ago might be gone. And sometimes nobody knows where any of that paperwork is. And you want to find what you have so you can expedite next steps in the process. And again, be proactive, prepare now rather than when somebody is telling you that you have to do this and you're under direct scrutiny. And through all of these, this is an opportunity to really center that fairness and shape what is perceived as fair. You don't just let your employees say, this is the fair thing. You get to say, we're being fair, but here's how we're doing it. And that perception really helps address some of the cultural issues in the workplace that I know Laura is going to be chatting about in a little bit.
Thanks, Alex. Well, with that, knowing that Laura's going to be coming up and joining, I'll be taking my leave and putting Laura on the hot seat so you can bring her through the next segment.
Well, thanks so much, Joel. That was fun. I will say, I think it's going to be a lot of fun putting you on the hot seat, Laura, now, but I guess you have a moment to brace yourself as well, because we will once again be going to our attendees for a couple of polls to get some real-time evidence as to what kinds of things are going on in your workplaces. So welcome, Laura, again.
Thank you,
And
Alex. The seat is feeling hot already.
excellent, excellent. Well, the weather is getting cooler. We got to keep warm somehow in late October. So the first question that we have here for our attendees is, have you observed an increase in conflict in your workplace overall? Just going to give it a couple of seconds here. I'm very, very curious to hear that because I imagine it will come to nobody's surprise that we have perceived increases in conflicts in workplaces overall. But always interesting to hear. I'm just going to give it another couple of seconds because there are still answers flooding in.
It's so exciting watching the poll results.
I know, right? I can't help myself. I'm like, oh, the bars, they're moving. It's also fun to see when they stabilize. So I will end it there.
All right.
Um, And so thus far, 30%, about a third have said no, no increase. That is great. And then the other, two-thirds have said yes. 21% are saying, we've had spikes in the past, not a huge difference here. But about half our attendees are saying, yeah, there's, been a noticeable change now. Couple more questions for you all. This next one is on psychological safety. So have you noticed an increase in employees raising concerns related to psychological safety recently? Again, fascinating to see. I will tell you, for those of you still voting, sometimes it really shifts back and forth in the poll. This one is staying very, very consistent. So I'll give about 3 more seconds.
There's also a comment that just popped up that somebody said, there's so much talk of trauma.
Absolutely. That's definitely, so we conduct a lot of, and you anticipated what I was going to say. It says, and trauma-informed practices.
Yes.
As many of our attendees know, we conduct a lot of workplace investigations. We've done that with a trauma-informed approach for a very, very long time. Before saying that was very, very common, and now we're hearing that as, asks and questions all the time. So in terms of our feedback here, about a third, again, have said no, no real increase in changes. 52% of attendees have said yeah, a little bit, and then 18% have said yes, quite a lot. So, 70% have seen an increase to varying degrees. And one more question for everyone before we get you in the really hot part of the hot seat, Laura. And this is about accountability and entitlement. Are you finding it challenging to hold people accountable without creating a sense of entitlement in the workplace? I'm curious to see if it's going to be a similar kind of breakdown, because so far it's been very, very consistent. 30% of people told us things are, nothing too much to see here. Things are, relatively stable. But this is definitely an interesting one. So I'm gonna, I think, stop the poll right here. And it is actually different. So 7% have said no, no challenge. The other 93 are evenly split, exactly between yes, sometimes, and yes, quite a bit.
All right. Okay. Well, it is very validating. And I can tell you from a corporate training perspective, right now, the hottest tickets in town are de-escalating conflict, communication training for having those challenging conversations, which are increasingly required in our challenging environment. And the other one is how not to foster an entitlement culture. I think that's pretty much one of the hottest tickets in town that we train on. So that validates, but this does too.
Absolutely. Well, that actually is a great segue to the first question that I have for you, Laura. And, as you said, we see a lot of these things coming through our doors. We're going to stay on the side of the optimistic, proactive employment lawyers, not the cynical employment
Indeed,
lawyers.
indeed.
But, part of the way that we do that is we identify the hot spots early and figure out what we're going to be doing about them. So certainly in our practice, we've seen quite an uptick in workplace conflict over the past couple of years. We've been addressing in various ways, as you mentioned, either through legal work, through training, things like that. From your vantage point, Laura, in your experience, what's driving this escalation?
All right, I'm going to preempt some of my answers by saying we have an overwhelming number of questions in the Q&A, which also underscores the challenging nature of our times. So I'm going to try to be as succinct in my answers, a huge challenge for me. But I'm going to try my best because I do want us to live up to the promise of giving at the back end enough time for Q&A. So with respect to your question, from my lens, what's driving this escalation? There are a number of factors, and there's been a convergence also of pressures. We've got the era that we're in as it relates to DEI resistance, geopolitical conflicts causing polarization of views, heightened mental health stressors, economic anxiety. I mean, I could go on and on. We're in a time where people really feel that almost threadbare. They're at the end. We've come through a time where, yes, to the comment that was made earlier, people are dealing with trauma. I was conducting a session the other day on it was a leadership session on what it means to lead, and one of the leaders said, "Listen, I'm just depleted." And I think that we're not focusing enough on the trauma that we all collectively experienced, coming through yes, I'm going to say the P word. No one wants to hear it anymore, but it is a big factor, the pandemic, right? And so all of that I've mentioned with respect to what contributes to driving the escalation, you know, all of these things, they spill into workforce and workplace dynamics. People bring their worldviews, their fatigue and frustrations into professional spaces. Added to that, we've got the pressures and just the frustrations and overwhelm that results from the era that we're in, where most of our communications are digital. And, as you just rightly pointed out as well in your segment, there are also some pressures from the hybrid models, which can amplify tensions. right? So just we're inundated now. Our inboxes are like spilling over with communications, and a lot of organizations are feeling that they're doing, more with less, and people feel afraid. And all of this is creating pressures. Not to mention, I could camp here for a while, but the nature of our communications and the tone, because electronic communications don't capture tone. So that can lead to tone misrepresentations. And I'd be remiss if I didn't mention social media and how it's blurred boundaries. Conflicts that start online often migrate into the workplace. And also, I would say social media is attributable, at least in part, to people losing that sensibility of what could be offensive to another person, right? We're seeing this in the significant increase in harassment and discriminatory harassment-based workplace investigations that are, the increase, Alex, we investigate. It's been astronomical in recent years. And all of these things, I think, are contributing factors. But camping on one, just to illustrate how the polarization of views can spill into the workplace. There was an investigation matter. I know you're familiar with it, Alex, of course, that we were engaged in as investigators to conduct. That really, I think it really underscores the shifting nature of misconduct that we're seeing today, as it really stemming from geopolitical strife. And this issue arose in the context of an individual, an employee who is Toronto-based in a global corporation, who placed something that was arguably offensive. He didn't feel it was offensive. It was just expressing his view. But it certainly was taken as highly offensive rather, by peers in other regions, including in Israel. There was a base of employees operating in Tel Aviv. And this investigation was very complex. Clearly people were harmed, and it also triggered further polarization within the workforce. So very, very complex. Now, thankfully for the employer, because it was very kind of factual that the employee did place these chats or his comments in the chats in the global meetings. Thankfully for the employer, they had policies that gave them recourse to address the behavior, including conduct expectations during meetings. And, there was very specific wording with respect to not having disruptive type comments in meetings, or in either comments in chats, or if you're speaking with someone. But netting everything out, this is a real example of how geopolitical conflict can bleed into the workplace and cause serious issues for employers.
Absolutely. I mean, with all of the different factors that you've mentioned, political, social, technological, all of those things impacting our lives, given how much time we spend at work and how integral our work is to how we see ourselves, it's not really surprising that all of this is bleeding into the workplace and how we show up at our jobs. But kind of looking at the somewhat flip side of that, quantity aside, looking at quality or, characteristics, I suppose, are you finding that the conflicts are looking different from what we may have seen 5, 10 years ago?
In some senses, yes. In some senses, significantly. So yes, we are seeing the same conflicts that we may have seen 5, 10 years ago. But I'd say in today's workplace, the conflict has shifted from interpersonal friction to more values-based confrontation. Today's disputes are, what would I say, they're centered on identity, fairness, or perceived rights, rather than task disagreements or personality differences, which, as I said before, of course, still exists. But employees now feel emboldened to challenge authority, often framing disagreements as issues of respect or safety. And they're a few keystrokes away through ChatGPT and Google of feeling that they have a solid sense of their rights and entitlements. So, I'd add to that there's also a huge workplace trend that employers are dealing with, where their employees are quick to assert that they don't feel psychologically safe to attend work or work with a particular manager or a teammate. And this is a huge emerging issue within the workplace.
And, we've seen that in some of what we got from our polling, where 70% of our attendees have said, people are increasingly raising concerns of psychological safety. When we think about this as the big issue, an emerging trend, what do you mean by that? What are some things employers should be keeping in mind?
Well, I've been pretty much characterizing it as psychological safety is the new frontier of occupational safety. Like when we used to think about safety within the workplace, we think of physical hazards, hard hats, safety boots. Now employers have to ensure that they're legally and culturally maintaining environments where employees can express concerns without fear of reprisal or retaliation. And it's not about being kind of virtuous and just higher purpose. It's a practical operational consideration because in this context climate we're in, if you don't, then you're not going to be able to attract the talent you need. So at its essence, it's important really to consider what is psychological safety, and it involves an environment where people can take interpersonal risks, ask questions, admit mistakes, or disagree without fear of negative consequences. And when people feel that they can't, or they feel that there's a manager that's particularly bullying, or they're being ridiculed, or they're being excluded, this is where you hear, concerns of psychological safety. But distinctions have to be made because there are occasions, again, we tend to hang out in the dark cave where the wheels pop off, and that's our skew. But there is a distinction, because it shouldn't be unlimited free speech or a shield from accountability. When you're thinking about psychological safety and ensuring that it's not being abused or weaponized as a common refrain within your environment, it's about balancing candor with care and ensuring respectful communication. And this balancing is challenging. I mean, I remember we had a case not too long ago that involved an employee who was asserting that what was alleged to be offensive conduct was her right to express herself because she should be able to show up authentically to work. But her, objectively, her conduct was offensive, it was divisive, it was counterproductive. And her leadership was at a loss because in how they rolled out some of their equity and inclusion work, that whole notion of being able to show up authentically is something that they were promoting, not realizing that you also have to counterbalance that with making sure you very, very clearly identify, because people don't necessarily know these days what's appropriate conduct versus what's inappropriate conduct within a workplace.
And so with all these organizations, trying to make sure that people are feeling psychologically safe, because those are big buzzwords. Again, we've talked about employees becoming aware of certain terms of art. There's ones you hear, I'm not feeling psychologically safe, or, I'm being harassed. Those are big ones. What kinds of issues are you seeing, or are there any specific risks that you think are, very, very clear or very, very noticeable of when employers go too far in doubling down on that empathy and flexibility?
Absolutely. And, again, we were in a time when the labor market was very challenging. And, it wasn't necessarily always the case that it was, leaders wanting to be higher purpose and empathetic. It was, employees' priorities had shifted, their demands had shifted. They want flexibility, they want autonomy, agency, and working, many of them, on their own terms. And so employers, desperate for talent, and a lot of employers unfortunately doing, I call it got a pulse hiring. Got a pulse, you're hired. As a result, they were making all kinds of promises and overextensions, leading to, we talked about the risks of, constructive dismissal, for example, because that's also an output of this. But, when it came to, providing employment terms on employees' terms, a lot of employers were over permissive. So, empathy and leading with empathy has been a theme, a very strong theme over the last several years. And it's a theme for a reason, because, leading needs to be, particularly in the era we're in, more human-centric. That's the expectation. That's what you need. Employees want to feel that there's meaning in the work that they perform. They want to feel connected. They want to feel that they're contributing. And these are things that the surveys, all stats bear out to be true. And you're not going to have the talent you need if you don't. But the truth of the matter is empathy is essential, but overcorrection can erode fairness and accountability. So, some leaders, unfortunately, what we find is they equate empathy with avoidance.
Mm.
So, stepping hard conversations to protect relationships or to retain employees. And that's why, again, another hot ticket in town is the kind of communications, how to have challenging conversations within the workplace so that you can performance manage, you can performance correct, and the things that are necessary. So, if you don't pair empathy with clear expectations, you can create uneven standards. And oftentimes, I think there was a comment or a question that relates to this, because it's not only about uneven standards or the inconsistent application of policy, it's also employee resentment.
Mm.
Right? And so that extension of empathy is perceived as favoritism, and employees feeling that they're not getting a fair deal. So leaders have to differentiate between being kind and being permissive. There was a case that we had that actually it escalated to the Human Rights Tribunal. It involved an employee who it settled ultimately, but this employee that um, had mental health challenges and was commiserating, or shouldn't say commiserating, was raised them with his manager actually, and the manager was commiserating with the employee, essentially saying, I'm challenged as well. I've had all of these issues, and it went back and forth with the manager overextending an empathy and not escalating the issue as he ought to have. And ultimately, that employee rolled on him and said, you failed to accommodate. I raised all these issues and you acknowledged them. And so, that manager was, individually named. So in the human rights application. So, these are things that are really critical to bear in mind, that yes, there has to be empathy, but there has to be accountability. Otherwise, you're going to find yourself in not only a culture of entitlement, but you're also going to create exposures to liability.
And I mean, just to briefly revisit the last polling question that we had, we found that 93% of our attendees, so overwhelming majority, have said it really is so challenging to do that. But as you have said repeatedly, Laura, it's so important to be able to be empathetic, hold people accountable, make sure they're performing their best, but not create that sense of entitlement. So when you do, if you kind of aren't able to walk that very narrow path and the empathy starts tipping into entitlement, what does that end up looking like in practice?
Well, there's all different types of manifestations. So employees using psychological safety language to resist feedback or accountability. So weaponizing the term, like, I don't feel safe, being criticized, for example, or receiving performance feedback. Increasing customization demands. So expecting unique expectations for schedules, workloads, or feedback styles. Over-reliance on wellness framing for performance issues. Entitlement culture, as we talked about, that emerges when empathy isn't balanced with mutual responsibility, which means that, instituting any change, instituting policies, practices, new kind of operational procedures, that's met with pitchforks and torches, right? Hell no, we're not doing this. And it's very, very difficult to lead when you don't have the balance. And, just to give it kind of give you a sense of how, when the balance is skewed, what this can be like. So, if you have too much accountability without empathy, right? Because you can go be, imbalanced in the other direction, it can create a compliance culture. And that's where people follow rules but don't engage or innovate. And in this day and age, for the reasons I just momentarily discussed ago, It's hard to retain talent because employees feel controlled, fearful of mistakes, and less willing to speak up. And it does erode psychological safety. And another thing, it also creates organizations that are fraught with risk because conflicts go underground, leaders mistake silence for alignment, and then, oftentimes, employers don't realize that they're in a powder keg environment, and when that goes off, when it's ignited, what they're facing is, toxic poison work environment claims that can be monstrosities to resolve. Then the other way, if it's the scale's tipped too much in favor of empathy without accountability, that's when we have that, entitlement state. All the rules are negotiable, standards are inconsistent. Well-intended leaders avoid necessary performance conversation. So, fairness erodes because employees perceive unequal treatment, and strong performers disengage and leave. And then, the problem is that over accommodation becomes unsustainable, creating organizational fatigue and frustration. So the balance point, the sweet spot, is where you anchor empathy and fairness and consistency. Accountability, when practiced with empathy, reinforces trust. That's what you want. It signals that expectations apply equally to everyone. And true psychological safety comes from knowing the boundaries and trusting they'll be upheld consistently.
There's so much to unpack there, but I know we have questions that we want to get to. So
Yeah.
For the last question I'm going to pose you, I was just going to turn up the heat on the seat a little bit, just can't make it too easy. Given everything that you've said, the situations we've been in, the kinds of environments, and maybe some missteps where organizations have contributed to these sorts of issues themselves, where do leaders and HR even start if they want to recalibrate, really create that environment where they are empathetic, but they're not reinforcing any of these issues?
Well, so now is the question in the context of where you're in an entitlement culture state?
Yeah, so how do you recalibrate? How do you make sure that you're fixing those? Or, if because you gave us both options, I leave it to you wherever you want to take us. But, where do you start as a leader or as HR? How do you fix the mess you find yourself in?
Well, first of all, well, let me start here. So I think it's important to rebuild clarity and consistency. So define standards and communicate the why behind them. We're in many eras, but one of the eras we're profoundly in is the era of why. People want transparency, they want the rationale, and it's important to have that, particularly when you're communicating and implementing, tough decisions or major changes. Um, Also, accountability conversations need to be normalized. So, and another key thing is issues need to be addressed early, not when they've escalated. And oftentimes, early intervention or kind of early addressing is a function of leaders being equipped how to have those challenging conversations so things aren't kind of swept under the rug or dealt with when if you don't have communication adeptness to deal with something at the front end, you certainly don't have it to deal with the issue in the back end when the mushroom cloud goes off. So that's another thing. Uh, Modeling human-centered leadership. So, you've got to combine compassion with courage, right? And courage, again, that is, again, having the tough conversations, but knowing that, we are mere mortals, right? And so we have to take individual circumstances into account, particularly given the times that we're in. But those are some things that I would say are really critical. But one of the things I would say underscores it all is you have to ensure that leaders have the capacity, have the training, have the upskilling to deal with the issues that we're dealing with in the challenging times that we're in. And that's why, the programs we run, and others run too, but we've got a proprietary one called What It Means to Lead that really helps new leaders in particular and refreshes those that have been leading for a time, but not in these times, on how to kind of course through and successfully lead in the climate that we're in.
Thank you so much, Laura. Well, I know we have quite a few questions, and I think we did promise that we would try to get through as many of them. So, Joel, if you want to come back and join the party, I think
Yes,
we're going to be
please.
diving into some of these. And please, for all those of you who may not have had a chance to put in your questions in the Q&A yet, or if anything else comes up as we're discussing, please feel free to keep populating those.
Thanks for inviting me back. I know the two of you are just coming out of the last segment there, so why don't I jump in with a question, as I've had the benefit of being able to look at the questions during Laura's segment a little bit. Alex, I have a question for you to kick us off here, and it relates to family status accommodation that you were talking about. There were a few questions there, so suffice to say, it was interesting for the audience here today. So first question I wanted to ask Alex. Is it reasonable for employers to accommodate an employee who doesn't have daycare but has their child home, even if it's definitely proving to be a distraction?
Start me off with an easy one, huh, Joel? Um, so, I mean, the first, because I answered the first specific question, I have to be the first to give the standard lawyer answer of it depends on the circumstances, and this isn't legal advice. We would need actually a lot more information. And honestly, that's very true for accommodation because it's so specific. Is it reasonable for employers to accommodate an employee? Yes, it is reasonable to accommodate. Now, if you're asking, if the question is more, is it reasonable to have the employee at home and during their 9 to 5 hours, they are providing full-time care for a child every day? Quite honestly, probably not. But you would have to look at it in the circumstances, and a lot of it is going to depend on when we say child, what are we talking about? Are we talking, a 2 or 3 year old, or are we talking about a 16-year-old who is legally a child and might be, at home but going to school remotely for a period of time or attending a summer camp virtually for a little bit of time? Because it's so circumstance specific, there may be situations in which, you are able to accommodate the employee. And some of the accommodations that we've seen and explored with employers are things like really, really flexing hours. So if it's not really important when the employee performs work, it may be that they do it in chunks. Now, of course, some of these things get challenging because obviously they're outside of exempt professions and roles. There are limits on how many hours an employee can work. There are requirements on how many hours they have to have off work. So, if they're working from 7 to 9 in the morning and then like 9 to 12 at night, you might be running into some issues. But it's definitely possible. The key takeaway that I would leave you with is you have to go through that procedural accommodation process. You have to ask the questions. You can't assume that it's a default no, but if you ultimately land on this is not a reasonable accommodation, that may very well be fine. You're going to have to show your work, how you got there, and then document it clearly.
That's a very good segue to another one, if I can keep you on the hot seat for one more,
Sure.
Alex. This is another is it reasonable question. So an interesting one and allows you to go a couple different ways with it. Is it reasonable to ask an employee to find alternate childcare if the hours of their preferred arrangement do not work with the office hours?
So again, this is going to be one where you really have to explore and make sure that you're evaluating it in an unbiased manner, because if the question is this their preference, then yes, you may be able to push and say, well, that doesn't make sense. We can't accommodate that. If it is not a preference and it is a necessity, and again, we've heard this in our work, and we've heard this, quite frankly, colloquially as a parent of a 2.5-year-old. I've heard people say it's very hard to find childcare. So, you have to look at what options are available, but employees also have to work with the employer. And we've seen a lot of that case law where it's not just up to the employee to say, this is it, there are no other options. I have to have this. Again, reasonable accommodation is the goal, not perfect accommodation. And look, we all hope that it doesn't get to this point, but sometimes where you land with accommodation is we can't make the changes you need. You can't work without those changes. So perhaps for some time, you just need to take a leave and you need to, take some time, sort things out, and then come back. And you're absolutely welcome back. And again, not so much in family status accommodations, but we have had these in situations where other protected grounds in the Human Rights Code have been triggered. And ultimately, that's an option as well. But again, same thing, explore and make sure you're holding the employee to their obligation to cooperate with you as well. They don't get the ultimate say. It's really intended to be a collaborative process where you land on that reasonable, hopefully middle ground that everybody can work with.
All right, I'm going to jump in because Joel's been off the hot seat and had a chance to, reboot and refresh himself. So, Joel, you're up next with some of the questions that we received for you. So, the first one is we use a third-party adjudicator to assess those going on medical leave of absence. This is our current process. However, is there anything we need to do more since we're not the one adjudicating the file? Basically, do we need to do more?
It's a great question. It's something that I spoke to a little bit and didn't get as much of a chance to during my segment, so I'm glad this came up. It's it's generally not something I recommend to clients. I'll say for myself to rely entirely on a third-party adjudicator. I spoke about the idea that you can't rely entirely from a legal standpoint. You need to make sure that you are getting, limitations information. You're meeting those procedural accommodation steps that I was talking about. So you need to do that to meet the minimum requirements. But beyond just that, really farming out the accommodation process to a third party, whether that's, just relying on the STD adjudicator or the LTD insurer to get the information and tell you when the person can come back to work, or just in the day-to-day accommodation process, having a third party manage that process. The same types of issues tend to arise where they're getting usually a lot more information than you as the employer would be entitled to. They may be getting diagnosis information, medical reports, really detailed information that as an employer you definitely should not be asking for and should not be seeing. And then they also can't tell you that information because they have their privacy obligations. So they're in a bit of a limited situation. You're limited in what information you know. If you ask questions yourself of the employee's doctor and get that information directly, you can frame the questions in a way where you get as much information as you're reasonably entitled to and need to accommodate to be able to manage that process effectively. And there's also, I'll say, risks that you can face if you do have that third party. I just a few months ago, I was helping a client with a situation where they had a similar arrangement, third party who was helping them with the accommodation process, and there was some broken telephone, I'll say, between the employee who was off, the third party who was helping with the accommodation process, and the employer. And so the way that an accommodation need or a limitation was framed for the employer by the third party was not something they could accommodate, and that's what they told the adjudicator. But then the employee ended up leaving. There was a human rights claim. Some more information was obtained, and it turned out what the employee told the adjudicator wasn't quite what the third party wasn't quite what the third party told our client. And so our client said no to what was said to them, but that's not actually what what the employee needed, and they could have accommodated what that employee needed. And so it turned out they didn't provide the accommodation at the time that they would have been able to, and that was in part what this employee was saying, they were responsible for in terms of failing to accommodate. Had they got the information directly, they would have known what they were dealing with and been able to accommodate like they could.
Indeed. And I just to cluster questions, I've got two related questions for you, Joel. So in a position where deadlines are key to the role, how do you accommodate where the doctor's note says no stress and no deadlines?
So that's a great one. I know we got a couple of questions very similar like that. That's a situation we're seeing more and more. And we were talking about uncooperative doctors. This is another way that they can be uncooperative. Sometimes they're not giving you much information, and sometimes they're just telling you things that as an employer you really don't know what to do with. If the job requires deadlines and the entire thing the doctor has said to you is no deadlines, well, how can they do that job? Now, in some cases, Alex, you were talking about it a minute ago, it may be there's a leave of absence because you just can't accommodate for them to do their job while you get updated information. it depends on, how long they need to be off, or how much, how much of an issue it is for them at the time. You may be able to keep them in the job temporarily and ask follow-up questions of the doctor and say, that's not good enough. I would imagine I can accommodate. Here's how the job works. Give them more information and then say, with that in mind, can you tell me the limitations that relate to this job? Not no deadlines, the limitations. And if it really is no deadlines, absolutely positively, that's not something they can deal with. Tell me that more clearly. And then you'll know as the employer, if that's the answer, you're not going to be able to accommodate that. They're going to need to take that leave pending, recovery, so they can deal with deadlines, because that's what the job is. Unless it's another job they can do that doesn't require deadlines, and you may be able to accommodate them in that other role temporarily. That's another thing you can consider as an employer.
Okay. And the second one, 'cause I said there were two. Generic mental health issues are problematic when I get a note from a family physician saying the employee cannot be subjected to stress or strict deadlines. How do you respond to the employee when the doctor doesn't provide restrictions, like in that case, like the case that you also discussed, a case like that, Joel, but provides the defined accommodations?
So again, really, it's a process of getting the information that you need. And I'm going back repeatedly to that procedural duty to accommodate, because it really is it's a tool. It's an obligation, but it's a tool. Ask those questions of the employee. Ask those questions of the doctor. If you're getting recommended accommodations that you can't reasonably manage, if you're not getting just what the limitations are, go back to that doctor and make it clear that you need limitations, and make sure that you give them enough information about that role, and what the employee is responsible for doing, so that they can really have the tools and the information to give you their work-related limitations, as opposed to just, what the employee wants based on what they're telling their doctor.
I think, Laura, it's time we got you back on the hot seat, because
I
now
was
it's
just on the hot seat.
the
So
past
hot.
is the past. We're warming it back up. So one of the questions that we got here, which is it related to something that you'd mentioned, Laura, in your segment, you were talking about sometimes we get pushback from employees who are just like, oh, no, don't feel safe. How do you deal with that when psychological safety is weaponized against an employer? How do you address a potentially legitimate issue, but also the way that it's presenting in the workplace and the challenges that it creates?
I would say this for a lot of the issues that we've discussed. The best way of addressing it is to preempt it. So we know that psychological safety and some other challenges and some other claims within the workplace are being weaponized, and for some employees, not all by any stretch, to leverage certain conveniences and having their roles customized to their interest. And what I say to that when I talk about preemption is you have to, call the thing a thing in terms of bringing training within the workplace to make distinctions between what psychological safety is, what it's not, to make sure that certain behaviors that are inappropriate are well defined, and also ensure that obligations, including in the realm of accommodation or disability management, that they're well defined in terms of what the responsibilities are on the employees, on management, and so that individuals understand the accountabilities they have, and it's harder to weaponize certain things like I don't feel psychologically safe. The other thing that's important is to be responsive, because you can only be so preemptive, and because we can't see around all the corners. So there are going to be times when you need to respond, and ensuring that people leaders aren't sweeping things under the rug, aren't delaying in responding to concerns that are raised by employees is really important, because the weaponization of psychological safety or psychological lack of safety can certainly be augmented or enhanced by real stories in the workplace where the employer or managers haven't been responsive, and other employees can say, well, just like in this case, I'm experiencing something similar. So preemption, responsiveness.
And maybe within that spectrum, or as another, I guess, tool in the tool belt, one of the questions that we had is, do you think that employers need to increase workplace investigations to address some of the workplace challenges?
I think, well, Employers have to ensure, again, responsiveness. And you're right. I'm so happy you called that out as a spectrum because there's so many other things I could have mentioned there, including ensuring that, well, I did kind of mention that, ensuring that your policies do set out the expectations. But increasing workplace investigations, I don't think that's necessarily the case. Ensuring you are conducting workplace investigations and equipping your people leaders to understand when they have to escalate matters so they can be at least triage to determine whether workplace investigations need to be conducted. That's really important. Also understanding the scope of the requirement to investigate, that it's an investigation that's appropriate in the circumstances. So what causes a lot of employers and managers to recoil when they're facing an issue that could lead to an investigation is they're thinking that they have to be these elaborate kind of monstrous events within the workplace. And some do call for significant scopes of an investigation given the allegations. But oftentimes what enhances the scope of an investigation is, number one, not having the training on the ground for individuals to employees, not employees, but managers and HR to know how to properly and effectively triage for whether or not, let's say, even a complaint hits the threshold of what needs to be investigated, or fumbling the ball early on in terms of not preserving evidence or not making the appropriate steps to ensure containment. So again, it's not a matter of increasing workplace, maybe for some, but it shouldn't be a matter of increasing workplace investigations. It's a matter of ensuring that you have the capacity, you've got the training, and that you're equipped to really front-end triage and properly scope out what the employer's obligations are to deal with any complaint that escalates.
I can't help myself. I have to add, because on that last issue, the threshold assessments, I mean, we've had so many issues there on both sides. Employers investigating too many things because somebody says I'm being harassed and they say, okay, investigation. But when you look at it, they're like, I'm harassed because my manager told me that, gave me constructive criticism on this job that I did, not something that should have been an investigation, versus, you get something that doesn't use the buzzword and then it's not investigated and it really should have been. So it just comes up so much. And I know all three of us have seen it so often that I'm really glad you had an opportunity to double down on that, Laura, on this question.
Well, we only have 4 minutes left, and we want to be respectful of people's time. So just a couple of things before I think Alex should go on the hot seat again if there's more for Alex.
Yep.
Although actually, I
Absolutely.
think you should go on the hot seat because there's one or two that relate to litigation that haven't been asked. So I do want to go there, but I just want to ensure that we remind everyone that we are going to be sending out our kind of the summary of our talking points. And because we did receive a number of questions, we may cluster them, but we'll also enhance what we're going to send out by providing you with the questions and just some summary points in response to the questions that we don't have the time to get to. So Joel, let me see. There should be one here at least, and there are, here's a good one for you. Based on the challenges we're seeing in the courts, would you recommend companies use fixed term agreements?
It's a great question. It's a step that a lot of employers think will help them, and unfortunately, it often goes the other way. And so, I was talking about termination clauses and the reality that termination clauses are often found to be unenforceable, and so and that ends up resulting in common law notice. Like I was talking about, much more termination obligations that need to be paid. And so, what some employers do is say, okay, well, then why don't I just cap how long this employment relationship is going to go on for with successive fixed term agreements? And there's two main issues with that, and these are the two reasons why I generally don't recommend that employers do that. One, when you're using a fixed term contract, if the termination clause to terminate it early is not enforceable, common law notice is not the standard that the employee is generally entitled to if it's a true fixed term contract. The employee has to be paid for the balance of that fixed term. So you give someone a 1 year fixed term, they're not working out, you want to let them go after 2 months, and it turns out your termination clause is no longer enforceable because the courts have come out with yet another decision that creates some concern there. Well, the downside, the risk that you face if a court does not enforce that early termination clause is you pay this employee 10 months. And for a 2-month employee, it's very, very rare that they'd be entitled anywhere near 10 months at common law. So now you're paying them more than you would otherwise. The other concern is if you keep on using successive fixed term contracts, the courts might just throw that out and say, well, this isn't a true fixed term relationship. This is an indefinite term relationship. Is you can just keep doing the same thing year after year after year, and then you can't actually rely on some other aspects of your contract either that you otherwise might have been able to with a legitimate indefinite term contract. Laura, you said let's get Alex back on the hot seat, and I do have.
Oh, do you have one for her? I don't know. I was going to say, I don't think we have time. Alice, consider me to have spared you because we're right at 1:59.
I'm game either way.
I
Let's
know
go.
you are, but I will say you're welcome because I do want to be respectful of people's time, and I want to thank everyone for taking the time to spend with us today. We don't take it for granted, and we truly hope that we've left you with food for thought as you continue to navigate the complexities of today's workplace. If, as you're coursing through the challenges and opportunities that our times present and you feel that we could assist, please feel free to reach out to us. And just in closing, and on behalf of all of us at Williams HR Law, take care, and we look forward to connecting with you again soon. Thanks, everyone.